Good morning and welcome to today's webinar. I'm Roddy MacLeod. I'm chairing today's event and I'm joined by my colleagues Derek Francis, Gordon Watt, Fergus Colquhoun and our practice manager Emma Potter. This is the latest in a series of webinars in which members of Terra Firma chambers have been presenting on a range of legal subjects. Today's webinar concerns private client practice, and there are three particular areas of focus. First of all, Fergus Colquhoun and I will be talking about some recent cases involving executory matters. Then Derek Francis will look at the application of section 142 of the Inheritance Tax Act 1984. And finally, Gordon Watt is going to present a case study on a range of legal subjects, including adults with incapacity and international private law. Today's seminar has been accredited as providing 1 hour of CPD. I say on behalf of all of the speakers that we want this to be an engaging and interactive webinar. So there is an opportunity for you to ask questions through the online platform on your Zoom pages. If we run out of time to answer any questions, one of the speakers will answer you directly by email after today's webinar. The slides from today's webinar will also be sent to you by our practice manager, Emma. And in due course, a recording of this webinar will be uploaded onto YouTube so that you can view it all again. Without further ado then, let me introduce the first presentation, which concerns some recent executory cases which have been decided over the last year or so. The presentation is in 2 parts. Fergus Colquhoun will start and he will discuss the important aspects of the cases which have an implication for practice. And then thereafter, I'm going to comment upon some of the potential lessons that we can learn for practice and the wider implications that we can take from these cases. I'm pleased to now hand over to Fergus. Fergus is our newest member of Terra Firma Chambers. He called this year and has a background in private client matters. He trained at a large private client firm and thereafter spent a year as an in-house solicitor in a large estate. He has a particular interest in trust and property matters. So, over to you, Fergus.
Yes, Roddy and I have selected 5 cases from the past year, which we think will be of interest to practitioners. And I'll start with Campbell's Executrix against Campbell's Executors, which, as you'll see, was an in-house case that was decided at the beginning of this year and featured the executrix of her mother's estate suing the executors of her father's. The facts which gave rise to this situation were as follows. In 1981, a family home was bought and disposed to Mr. Campbell alone. It was averred that Mrs. Campbell had always understood that she owned a 50% share in the property, and that Mr. Campbell had encouraged her to think this by, among other things, having her co-sign the standard security. The true position was discovered only in 2016 when she died. The pursuer sought, first, a declarator that the 1981 disposition was void, on the basis that Mr. Campbell had misrepresented the true position to the seller and that the disposition was therefore erroneous, and alternatively, for either conveyance of a 1/2 share of the property to the pursuer's daughter, or for payment to Mrs. Campbell's executory the sum of £200,000 as a 50% share of the value. And that final conclusion was intended to cover a claim in unjustified enrichment as well as fraud. Now, as that summary might indicate, the pleadings were somewhat confused, and the court dismissed the primary conclusion in very short order. If Mr. Campbell had induced the seller to make an error, it was for the seller to seek a remedy, not Mrs. Campbell or her executrix. But the seller had been paid and had therefore suffered no loss, and in any case there was no suggestion in the pleadings that she'd done anything other than what was previously agreed in the missives, which obviously runs counter to the suggestion that she had been acting in error. There's no misrepresentation if it reflects what will actually happen. Finally, seeking a declarator that the disposition was void requires a conclusion for reduction of the disposition and assisting the original seller to the action, neither of which was done. In respect of the alternative conclusions, the court held that the pursuer had failed to plead a relevant case. Apart from a very few suggestions in the pleadings, she failed to adequately aver that there had been an actual contrivance to deceive Mrs. Campbell. It amounted to little more than that Mr. Campbell had simply concealed the true position, without setting out the existence of any sort of agreement between the two. The title would be taken in joint names. And whilst mere concealment could found a case of fraud, that will generally require some pre-existing duty springing from a fiduciary relationship or similar. And such a relationship was again not pled in this case. The inner house therefore dismissed the action. So moving on then, next slide please, to Wilson against Watkins and another, which concerns an abuse of trust. The facts here are that in 2012, Mrs. Wilson's son-in-law lost his job, and she invited him and her daughter to live with her at her house in Kirriemuir, of which she was the sole owner. In 2013, she, with her daughter, attended a solicitor's office and signed a disposition in her daughter's favour, reserving a life rent to herself. By the laws of narrative necessity, relations between the parties thereafter broke down, and in 2015, Mrs. Wilson moved to stay with her other daughter and sought to have the defenders removed from her house. On realising that she was no longer the owner of the house, she raised an action seeking reduction of the 2013 disposition on the basis of undue influence, and ejection of the defenders on the basis of her life rent. The action then called before the Lord Ordinary on the defenders' motion to dismiss the first conclusion. Mrs. Wilson averred that she had been taken to the solicitor in 2013 under the explanation that she was to sign documents in respect of her future care, that she trusted her daughter, and that she had therefore not read the disposition. In considering these averments, Lord Brodie actually provides quite a helpful modern summary of the test for undue influence, emphasising that merely pleading a relationship of trust between the parties is not sufficient, and rejecting the pursuer's suggestion that A, the granting of a gratuitous benefit, and B, the absence of independent legal advice combined with that relationship was enough to raise an influence of undue influence. There must be some imbalance between a dominant and a dependent party before undue influence may be inferred, notwithstanding the presence of the granting of a gratuitous benefit. And in this case, his lordship felt that there was no real relationship of dominance and dependency that had been averred. Mrs. Wilson appeared from the pleadings to be a perfectly capable woman who was capable of looking after herself. And his lordship also observed that signing documents without reading them or even fully understanding them is not an entirely unusual occurrence, even amongst adults of full capacity. In addition, he observed that the reservation of a life rent meant that the transaction was not wholly gratuitous, and there had been legal advice available to Mrs. Wilson. Certainly, the solicitor in 2013, at the signing of the disposition, was not independent of her daughter, but no actual criticism of the advice that that solicitor gave was made in the pleadings, and Mrs. Wilson's case, so far as it related to reduction of the disposition at least, was therefore dismissed. Let's now leave the Court of Session and take a quick look at some Sheriff Court cases, starting with Mailer's Executrix against Mailer, which was decided in Perth last November. Now, this is really nothing more than a classic case of poor family management and poor expectation management. In 2015, Mrs. Mailer signed a will appointing the pursuer and defender her executors and leaving a £15,000 legacy to the defender and the residue to the pursuer. In 2016, the defender found himself in some financial distress, and Mrs. Mailer gave him £10,000, telling him that she would sort it with the pursuer. When, in very early 2017, the pursuer discovered the gift, Mrs. Mailer again promised that she would sort it with the defender. I trust that few indeed will be surprised to learn that this she signally failed to do, and she died in June 2017 without having decided the status of the gift. It would appear that, with a dreary inevitability, the relationship between brother and sister was irreparably damaged, and even pleas by the sheriff during the course of proof to reconcile went unanswered. The question then for the sheriff was this: was that £10,000 gift an advance on £15,000 legacy in the will, or effectively a loan to be repaid to the executory, or was it an entirely separate gift which had the effect of reducing the residue and therefore the pursuer's inheritance? That question fell to be decided on the facts, and the sheriff felt that the onus lay on the pursuer to show that £10,000 was intended as an advance, and the usual presumption against donation was held not to apply because the payment was made ex pietate, which is to say, out of a sense of natural affection and duty to a family member. Looking at the evidence as a whole, the sheriff concluded that the payment was a gift. Mrs. Mailer could have executed a codicil, but chose not to. The defender was therefore assoiled. Moving on to the case of LM against DG's executor, decided in Dundee early this year. This case is interesting principally because it shows how the interaction of the new sections 17A and 17D of the Prescription and Limitation Scotland Act 1973 with executries. Those sections, of course, relate to the exemption of historical child abuse claims from the 3-year limitation rule. In this case, as the name suggests, the alleged abuser was dead. LM had reported her stepfather to the police several times during his life for childhood sexual abuse, averring that between the ages of 11 and 15, he would rape her at least twice per week. Further evidence came to light in early 2017, and the deceased was interviewed by the police and served with a petition, but died 11 days later. And LM then brought an action for damages against his estate, relying on Section 17A of the 1973 Act. The defender sought to rely on Section 17D2 of the 1973 Act, arguing that a fair trial of the allegations would be impossible on the superficially reasonable grounds that A, the alleged events took place between 34 and 39 years ago, and B, that the alleged abuser was dead. In this case, though, the sheriff was not willing to dismiss the case purely on the basis that the abuser was dead before hearing evidence. And she observed that whilst the deceased could not answer for himself, there were several recorded police interviews which existed, which might allow his side of the story to be adequately put for the proof to be fair. And now she didn't discount the possibility that having heard evidence, she might uphold a claim under a defence under Section 17D. But looking overall, it would appear that death is not necessarily a bar to a claim of this kind being made. Finally, I'll come to the case of Smith against Carnegie, which was decided in Livingston earlier this year. An action of count reckoning and payment brought against the executor of an estate. Following the theme of the other cases discussed this morning, the background to this is one of very considerable family venom. Mr. Carnegie died intestate in 1999, leaving 4 children by his wife and a further child, then only 5 years old, by his live-in girlfriend of more than 10 years. The relatively modest estate was dealt with by his eldest son, and was, with the assistance of solicitors, largely wound up in that year, 1999. The executor was finally discharged in 2002, when the house, which had been occupied by the deceased's mother, was sold on her death. During the course of the executory, Mr. Carnegie's Beny made a number of claims on behalf of her young son, seeking, amongst other things, an advance payment of his claim in the as yet unrealized heritage property. Those claims were refused. In 2015, that son, now 19, started to make a number of fairly aggressive challenges to the executors about items which he alleged had been left off the inventory, including a BMW, an allegedly valuable stamp collection, and a caravan, and claims for medical negligence, PPI, overpaid banking charges, etc., which had not been pursued by the executor. These challenges appear to have had something of the kitchen sink about them, and were largely based on rumour and suggestion by his mother that there was something not quite right about the way that the executory had been conducted. And it's very clear that there was absolutely no trust at all between the parties in this case. Much was made of a joint bank account which had been automatically moved out of Mr. Carnegie's name when he died, and which had therefore only been discovered by the executor in 2016. Unsatisfied with the executor's responses to his challenges, the son brought an action for count reckoning and payment at Livingston Sheriff Court. The solicitor's files relating to the executory had been destroyed, and after a 4-day proof involving 10 witnesses, the executor was held to have provided a full account of Mr. Carnegie's estate and was assoiled by the sheriff. The BMW was a write-off. The valuation of the stamp collection that had cost £15 yielded a value of £8, and the failure to disclose a potential PPI claim for a man who died 9 years before PPI mis-selling became a widely known scandal was thought to be forgivable. There are a few interesting points to draw out of this case. The first of which is to observe that the action was brought fully 17 years after the executory was wound up and the executor discharged. A reminder that the duty of an executor to account is imprescribable in terms of Schedule 3 of the 1973 Act. The second is that the sheriff made clear that there is no obligation to include every single item owned by a deceased on a C1 inventory, which will no doubt come as a relief to the majority listening, irrespective of its value, and that failure through ignorance to include an item which should have been on the inventory does not mean that an executor has somehow failed in his duty. After all, that's why the EEC process exists. Finally, the question to be asked in an action of count reckoning and payment is how much, if any, sum the defender justly owes the pursuer, not whether the books were properly kept. So the complaint that one of the deceased's bank balances had been used to pay for the funeral and therefore been left off the C1 inventory was held to be entirely irrelevant to the pursuer's claim. As I said, the defender was assoiled by the sheriff, and that brings me to the end of my 5 cases.
Thanks for that, Fergus. Let me make 2 introductory comments to my part of the presentation, and the first is that to consider the weight of authority. And I think this is particularly important in the field of executory cases, because very often we're looking at the commissary jurisdiction of the sheriff court. And in addition to that, with the reforms to jurisdiction under sections 38 and 39 of the Courts Reform Scotland Act 2014, we're now seeing more cases, I think, coming through the sheriff court. Another example of this is in the remedy of reduction on the basis of facility, circumvention, undue influence, capacity. An example of that is the case of Hanton against Donee, which was decided last year. So we're seeing new areas of jurisdiction in the sheriff court, and we're seeing also cases of under the privative jurisdiction of the sheriff court, now seeing more cases. An important point about that, which also translates to decisions of a Lord Ordinary, is that a decision of one sheriff is not binding on another. Equally, a decision of one Lord Ordinary is not binding on another. So of the cases that we're looking at today, the first case of Wilson is binding. It's a decision of the Inner House. And it may therefore be important when doing case analysis, analysing the decision, to think about the weight of authority as to whether or not it's an example of a case or whether there is an authoritative principle or proposition which is being teased out. The second point to make is that I'm not advocating, in my following comments, I'm not advocating any particular standard under which us as legal professionals should be acting. And I think that's important because executive disputes are complicated. I'm fully aware of that. My practice is focused upon executive disputes. And that, in fact, encompasses quite a wide range of types of disputes, from typical actions of looking to reduce a will on the basis of forgery, for example, capacity, third-party influence, to questions of interpretation, i.e., is this document of testamentary effect, and if it is, what does it mean? And really everything in between that, from claims by cohabitants or legal rights claimants to executors' duties, trustees' duties, those with claims in an executory. Very often, and exemplified by the cases which Fergus has discussed today, there is an underlying family dispute. There is a fraction within family relationships. And that's a dynamic process over which we potentially have little control. And I think it's worth bearing in mind. Now, the reason I wanted to say that was to put some context to the comments that I'm going to make just now, because really what I'm thinking about is potentially future-proofing disputes, whether that is acting for a beneficiary or acting for an executor in the context that it is presumed or known that a dispute is going to arise after a person's death. And the common theme which I take from these cases, which I think relates to these cases and these sorts of cases, but also potentially has a wider implication for executory disputes, is contemporaneous note-taking. Now, what I mean by that is really an evidential matter in terms of looking at why a particular person did something at the time, and therefore whether or not that's going to be of assistance in bringing or defending a case at a later time. And by way of example of that, the question of note-taking could be important in the cases that we've looked at. So for example, in the first case of Campbell, we're looking at potentially establishing circumstances to rebut a challenge. In the second case of Wilson, and I realise that I've got mixed up with my cases earlier, Campbell is the case of the inner house, Wilson's an outer house decision. In Wilson, which is a case about undue influence, one of the things that's important in making a case on undue influence is access to legal advice. And it's not just the access to legal advice, it's the quality of legal advice. There's a couple of recent cases, the case of Horne, that's H-O-R-N-E, two decisions in that case, one by Lady Smith and one by Lord Drummond Young, which focus upon the importance of the quality of the advice that's given. Similarly, in Wilson against Anderson, which is an important decision of the inner house, and the current Lord President from last year looks at the circumstances under which legal advice is given to a testator. And in both of those cases, you see that there was an existing solicitor. In Wilson against Anderson, a new solicitor was brought into the fray. In Horne, the solicitor who was consulted by the testator was consulted by the telephone, and there was evidence that the person who was said to have impetrated the will and was found to have impetrated the will was beside the testator when he was giving instructions. Now, this is an important point, and again, thinking about contemporaneous note-taking, I appreciate that one of the difficulties in executory disputes may well be that legal advice, is privileged. However, contemporaneous note-taking, i.e. writing to say, I'm instructed, or this has happened, might not be privileged. And it's that sort of evidence which may become important in being able to establish that actually the testator did have access to his normal legal advisors and was making appointments. In Mailer, which is the third case which Fergus was talking about, there was no evidence, or one of the issues was the evidence of a gift. And in contrast to questions of testamentary interpretation, when one is looking at the intention of the testator from the four corners of the deed, it seems to me that there's a separate issue here in terms of evidencing the testator's wider intentions, not necessarily their testamentary intentions, but whether or not there was an intention to do something out with the terms of the will. So therefore, evidence of this by contemporaneous note-taking or letters between the parties may well have assisted. It may well have stopped a challenge having been made. Mailer, I think, it has a wider implication as well, not just in relation to note-taking, but it's an interesting case in respect of the possibility of one executor challenging another. Now, that point isn't flagged out in the case report, although there is a reference by the sheriff to having raised that as a preliminary point. It doesn't seem to have been taken. But that possibly gives a flavour in terms of the difficulties that one can see when one executor is suing another, and the difficulty then of making sure that all those who have an interest are convened into an action to make sure that a decision is res judicata, the administration of the estate. The third case which we looked at in the the prescription case is important, I think, and it's interesting because it puts into context the idea of an executory coming to an end. And now on Fergus's slide, there's reference to the case of Forbes against MacLeod. That's an important case that was decided a couple of years ago in the Outer House. And relying upon previous authority relating to trusts and trustees, Forbes against MacLeod was decided that it was still competent to sue an executor even after, on the evidence or the averments, that the executory had come to an end. Now, this is a potentially important issue in relation to the administration of estates, and I think perhaps we've not seen the end of it. Forbes against MacLeod doesn't talk about a case called Foggo's judicial factor against Foggo's trustees, and that's an inner house authority for the proposition that once an executor has distributed the estate, paid the debts, the executor's duty comes to an end. And perhaps there's a distinction there between an executor and then a trustee. And the important point, I think, here is that it may well be important to think about what evidence there is as to either a discharge of an executor or evidence that the executory has been wound up. And that may then give issues in relation to potential acquiescence or personal bar in bringing a challenge later on, even if the Forbes against MacLeod line of authority is correct. And the particular issue I think that arises there as well is that solicitors may not have an obligation to maintain records beyond a certain period of time. So it may become quite difficult in due course in actually being able to establish what has happened to a historic executory. Again, having notes at the time explaining what's happened may become quite important. And in the last case of Smith against Carnegie, Fergus has already mentioned that a trustee has an imprescriptible duty to account. Again, there is potentially an evidential difficulty if, in cases like this, an action of accounting is brought many years after distribution of estate. It may be very difficult to lead evidence as to what happened at the time if records are no longer required to be kept. But again, note-taking at the time explaining what's happening is potentially important, not least to be able to evidence something at a later stage, but also potentially in relation to saying, well, that was dealt with and done and it was accepted. And that might give then rise to questions of defences on the basis of personal bar or acquiescence. Let me give one other example in relation to the use of contemporaneous notes, and this arises potentially in undue influence, facility and circumvention cases, of which Wilson is an example. And it arises potentially when a testator is concerned that a challenge will be made as to their testamentary intentions. And one possible route around this is the testator giving an affidavit to sit with the will in relation to what they intended to happen. And that might arise in the circumstance where a testator comes in to see the solicitor, particularly if they're an elderly person, with a certificate from the GP to say that they are of capacity, gives a precognition, makes an appointment to come back in to see the solicitor against any risk that sending out documentation to the testator could be intercepted. And if the testator comes back in then and proves the precognition, an affidavit could be provided which sits with the will. And of course, one other issue in relation to note-taking and contemporaneous notes becomes the availability of the remedy of rectification under Section 3 of the Succession Scotland Act 2016. And of course, that is different to the question of testamentary intention, where we're looking at the four corners of the deed or sitting in the armchairs of the testator. Both of those phrases come from old authority. Rectification is slightly different, and it allows the court to look at extrinsic evidence such as correspondence. So the theme then, drawing all this together, I think is for private practice, thinking about testamentary disputes, it is potentially the availability of evidence and therefore contemporaneous note-taking. And we see the ramifications of that in the cases that Fergus has mentioned. So I hope those comments are of assistance and give some food for thought. And with that, I'm going to hand over to the second part of the presentation. That's in relation to inheritance tax. And I'll hand you over to Derek Francis. Derek is best known for his experience and expertise in tax law. He is an advocate, barrister, and chartered tax advisor. He is currently the chair of the Edinburgh Tax Network, and he presents regularly on different aspects of tax law. So, Derek, over to you. I think you'll have to unmute.
That's a plan. Good idea to unmute. That's the title of my talk. That's me. Next slide, please. It's an important one. That's the exemption clause. I'm trying today to fit a quart and a pint pot. You can do that, if at all, only at the expense of strict accuracy. So that's what I'm going to be doing. Next slide, please. I'm going to start from the assumption that you know the formal essentials of an instrument of variation. You need the concurrence of all parties who are interested, and indeed some more. So anyone, for example, who's a discretionary object, anyone who may be considered under a power vested in the trustees or others needs to join in. And if everyone can join together, and you've got 100% of those involved in the trust, they can go to the trustees. According to the tax lawyers, usually refer to it as the rule in Saunders and Gautier, but in Scotland it's Gray against Gray's trustees, Lord Gifford. They can go to the trustees and say, denude in our favour, or vary the terms of the trust like this. And where they do that in the context of section 142, and so long as they do it within 2 years, and they make a statement in the deed doing it, they can effectively have the change read back into the will so that it takes effect as if it had been present in the will from the death. But that's subject to one caveat. There needs to be no extraneous consideration. That's section 1423 of the 1984 Inheritance Tax Act. I'll read the relevant bit of it. Subsection 1 above shall not apply to a variation or disclaimer made for any consideration in money or money's worth other than consideration consisting of the making in respect of another of the dispositions of a variation or disclaimer to which that subsection applies. Now, what happens in reality in families, of course, is that there are all sorts of indefinite understandings. And the question, I get asked it not infrequently, I advise on it not infrequently, is, does that give rise to a gift? Is that extraneous consideration? It arose in sharp focus when I was giving a talk to private client and tax people in one of the very largest Scottish firms, where distinguished private client and trust solicitor asked me this. She did give me prior notice of it, thank goodness, but here's the question. Where an instrument of variation passes a qualifying interest in possession to a spouse to get spouse exemption, and there's a loose intention or understanding that outside the 2-year period, the trustees should terminate the trust with the hope that the spouse survives 7 years, trustees terminate, or the person with the interest in the trust terminates, doesn't matter which. Is that vitiating consideration? We've got a bit of Scottish case law on it. The leading case, a horrid cautionary tale, not much more than that, is the case of Lau. That was a case in which a stepson disclaimed a bequest of £665,000 free of tax in favour of his mother, so that it could pass within the surviving spouse exemption. But he received a sum of £1 million, which he said was really intended to help him set up in business. HMRC, not surprisingly, thought that maybe it might just be a consideration for the disclaimer. And indeed, the tribunal found as a fact that that was what it was. So an informal, in inverted commas, bargain is enough if it's sufficiently definite. And the touchstone, according to the tribunal, it was a matter of concession between counsel, was that it should be a quid pro quo. Those dicta are cited with approval by His Honour Judge Hodge in the Vaughan Jones case. It's a rectification case which follows Mr. Justice Reimer in Wills and Gibb. Next slide, please. In Vaughan Jones, the core issue was whether the court could rectify the omission of the statement that there has to be in a 142 deed of variation, that it and the analogous Taxation of Chargeable Gains Act provision should apply. Instead, in the deed in question, the parties bound themselves to join in a notice for capital transfer tax purposes. This was almost 20 years after the demise of capital transfer tax, so someone was using a pretty ancient precedent style. Incidentally, in Vaughan Jones, the issue arose whether 2.5 million passed in equal shares absolutely to the widow and 3 sons, whether the sons' renunciation of their interests so that they could pass to the widow through the spouse exemption might be vitiated by extraneous consideration. The intention being that the mother should make potentially exempt transfers of the extra which he got. And the parties were not assisted by the fact that in an attendance note, this was said, the bold bit is that which matters. The plan is to pay as little inheritance tax as possible at this stage, and for Mrs. Jones, the widow, to transfer as much as she can and survive 7 years. Now, even that was thought by Judge Hodge, whose observations are admittedly arbiter. Even that was thought not to be extraneous consideration. Next slide, please. Judge Hodge, who's a regular judge in the Chancery Division, Judge Hodge thought that it was the language consideration and money or money's worth was a technical expression which requires a bargain which is sufficiently definite. It doesn't include a generalized intention to give sums of an indefinite amount at an indefinite time in the future, which gives rise to no legally enforceable obligation. Now that I think is arbiter but right, and it's a straw in the wind. He didn't need, it's arbiter because he didn't need to decide the issue at that stage. It was an issue for another day. So far as I can tell, it's never actually arisen. And the case of Hill and Haynes also addresses the language consideration and money or money's worth, but in the context of the English equivalent of gratuitous alienations, and a similar approach is adopted there. Obviously, an attendance note like you've got in Vaughan Jones isn't what you want, because your aim is to distance yourself as far as possible from it being capable of being shown by HMRC that there are predetermined steps. Next slide, please. So it doesn't help. The obvious risk is that HMRC may seek to recharacterize the transaction. The best course is to leave to the beneficiary to whom the property is redirected to decide whether they want to make potentially exempt transfers, rather than to try to set the points in advance. But of course that only works where you've got sufficient trust amongst the parties. It's obvious that vesting of a power of appointment in the trustees or a power of advancement in the trustees is possibly more problematic, because it might, on a given state of facts, be possible to say that the trustees are chosen or have indicated mindedness to act in a way consistent with what is sought to be achieved. And simply advising about these issues is pretty dangerous. I'd suggest that the safe course is to state what the law is, adumbrate several distinct possible courses of action, and say what the consequences of those would be. But don't say what to do, because a sufficiently definite understanding that a certain course of action is going to be followed is just what you don't want. Next slide, please. But in principle, I would submit that if a widow or trustees are donees of a power to appoint or to advance, then without more, in principle, it should be assumed that they'll exercise it as is judged appropriate from time to time. So there's no setting the points. Yes, you don't want that attendance note in Vaughan Jones, but without more, the varying or disclaiming parties generalized intention that sums of an indefinite amount at an indefinite time in the future may be appointed by the trustees in a certain way come within Judge Hodges' dicta. You can gild the lily a bit by ejecting a qualitative condition which the object needs to satisfy in order to take benefit, a personal condition. That makes it less likely that it can be said that there's predetermination. Although it must be real, because if it's just there as a spoiler, you're into the line of authority which one finds in the Scottish Provident Institute case, which says that an irrelevant contingency can be disregarded. So it needs to be real. The problem for HMRC is that they really need to say that prospective possible exercise of power amounts to present consideration in money or money's worth. And that's very difficult. If they're going to say that, they need to rely on associated operations provisions in Section 268 of the 1984 Act, and or on Ramsey and the Inland Revenue Commissioners, as subsequently explained in Barclays Mercantile and Mawson. And they may not be able to rely on Barclays Mercantile and Mawson. It's never been conclusively decided whether you can, because in Countess Fitzwilliam's case, there are dicta from Lord Brown Wilkinson, which haven't been taken up, as far as I can see, in any subsequent case, which recognize, and it's an early recognition, that Ramsey is about a principle of construction, and so too is associated operations, and the former, the latter, on one view, excludes resort to the former. Statute has done the business which Ramsey would otherwise do. Next slide, please. Associated operations is about turning disparate bits of action into a composite disposition. What it's not about is turning a disposition into consideration, which is what HMRC need to do, if it isn't that ingrained. Associated operations, the fiction, goes to what a disposition is. And 272 of the 1984 Act states that disposition includes a disposition effected by associated operation, but it says nothing about whether one disposition is consideration and money or money's worth for another, for the purposes of 1423. You're back to Judge Hodges' dicta. A technical expression needs to be sufficiently definite. And on one view, becoming the object of a power doesn't amount to consideration for disposition at all. A power confers no interest. The trustees are not bound to act upon it. They may or may not as they choose, particularly if it's not a fiduciary power. For example, a life renter's power to appoint the fee and remainder can be released by the trustees. It's a power in gross. It doesn't enter upon that which is enjoyed by the donee of the power. And a disclaimer in return for a contingent space that the power should be exercised is probably not made for consideration in money or money's worth at all, because what you have by virtue of being the object of a power isn't an interest of any kind. Trustees needn't exercise it. If it's a power in gross, it can be released. Next slide, please. If you get to it, and on one view, as I say, you don't, you're into Barclays Mercantile and Mawson, and the repackaging of the Arrowtown case, the dict of Permanent Justice Ribeiro in the Hong Kong Court of Final Appeal. Read it short. The ultimate question is whether the relevant statutory provisions construed purposively were intended to apply to the transaction viewed realistically, and obviously ranges as well. If a series of transactions is intended as such, Plummer, Scottish Provident, Rangers, etc., say that you can look to the totality. If that sits with the legislation, you're not stymied by an irrelevant contingency, but that won't make it, next slide please, it won't make it consideration if that is not what it is. So HMRC's problem isn't just solved by elision of the steps. That may very well be achievable. They need to equiparate future possible exercise of power with consideration in money or money's worth. When it's not that on one view, economically or juristically, if you play your cards right. On one view, they can't use 268 or Ramsey to convert into consideration something which isn't that. Don't say it couldn't be done in any factual circumstances because you've got the Scottish Provident line. The position differs only in degree from what is said by Judge Hodge. Next and final slide, please. Absent predetermination, someone who disclaims absolute entitlement in return for a space of potentially exempt transfers under a power doesn't get consideration in money or money's worth for the disclaimer any more than the director in the Ford and Q case, which is discussed at length in Rangers, the director under an EFERBS who took a contingent interest in an unapproved benefit scheme, turning upon his being employed at age 60, got consideration in money's worth. The cases suggest that that which you get needs to be vested. So there's fertile ground here for planning opportunities. Ladies and gentlemen, that concludes what I have to say about this. Thank you very much for your attention.
Thanks, Derek. I'm going to pass over now to the final speaker, which is Gordon Watt. Gordon's practice encompasses a range of subject matters, including tax and related matters. He's a chartered tax advisor and experienced in a range of contentious and non-contentious tax matters. Before I do so, Gordon, just to say something for all our delegates who are watching today, just to remind you that the slides will be sent out to you after today's webinar. And there is still an opportunity to ask questions. I suspect, looking at the clock, we may not have time to answer them today within the hour. But if you do have any burning questions, you can either submit them just now or indeed after the event to one of us directly. All of our email addresses are available on the website. So, Gordon, over to you.
Roddy, thanks very much. With the luxury of batting at 4 in the time remaining, I'll just try and score a few quick runs. I appreciate we've only got about 10 minutes on the clock. What I'm going to do, as you say, Roddy, is present a case study which draws on recent experience, including, interestingly enough, acting as an expert witness in Scots law in this area in English proceedings, to illustrate some engaging, at least I find them quite engaging, interjurisdictional points involving international private law incapacity and the inheritance tax implications of the particular scenario that is under discussion. So, pushing on, let me introduce you, if I may, to our protagonist, who's Dr. Matt of Zermatt, an elderly widower with 2 grown-up children, his money on deposit in Edinburgh, investments in London, a large farm in Scotland and various properties in England, and under a will from 2015, he leaves his whole estate to a discretionary trust for his children and their descendants. He's domiciled in England and resides in London. Now, in recent years, he's been living with Françoise, qualified BASI 5, a retired ski guide. She is now thought to have acquired an English domicile of choice. Matt's health is sadly declining. He's now bedbound, and Françoise has been caring for him at home for the last 6 months. Matt and Françoise married 4 weeks ago in a small private ceremony. Matt's children, who were not invited, were taken by surprise, and shortly after the marriage, Matt's condition deteriorates, so much so that he loses capacity to make a will. Now, under English law, marriage revokes the will from 2015. So as a result, an application has been made in the Court of Protection in England by the children. There, the court has power under the Mental Capacity Act of 2005 to authorize the making of a will for a person who lacks testamentary capacity. That application is successful, and a statutory will is duly made on Matt's behalf, which revokes all prior wills, and it contains substantial, generous monetary legacies to Françoise and leaves her also the couple's house. The rest of Matt's estate, purportedly also including the Scottish heritable property, goes under the statutory will into a discretionary trust for Matt's children and their issue, which mirrors effectively the terms of the original will 2015, but there's an innovation because Françoise is also given a life interest in the income from the trust. So various interesting issues arise from a Scots law perspective here, and the first one we should look at is the effect of the marriage on the will from 2015 as it relates to the money in Edinburgh. That's the movable property, obviously, in Scotland. Now, the basic rule here, everyone will remember, is that the essential validity of testamentary provisions disposing of movable property is decided by Scots law by reference to the law of the testator's domicile at the time of his death. But the specific question of whether marriage revokes a will of movable property is characterized primarily as a matrimonial issue, not a testamentary or a proprietary one. Case law, some of it rather dated, is what we have to rely on to establish that proposition. Go back to the case of Westerman from 1905. And in that one, a will had been made by Mrs. Westerman before she married. When she was domiciled in England, she acquired her husband's Scottish domicile through the marriage. And as a result, the effect of the marriage on the will was decided applying the law of the domicile of her domicile at the time she was married, which was Scottish. So the will stood as regards movable property. Now, in our scenario, Matt was domiciled in England when he married, so the marriage revoked his will from 2015 in relation to the English assets, obviously, and also to the movable property, that's the money in Scotland. This isn't the case, though, however, in relation to heritable estate. Sorry, I'm in demand. This is not, however, the case in relation to the heritable estate in Scotland. The majority view on that point, if not quite the consensus, is that the effect of marriage on a will dealing with Scottish heritage is governed by the lex situs. We have to go back to the case of Caithness for that, back to 1891. So in this scenario, it's quite likely that Matt and Françoise' marriage didn't revoke the will from 2015 in relation to Scottish estate. Now, this proposition is not entirely free from doubt, but the usual approach of Scots law, bear in mind, is to decide the essential validity of provisions in a will dealing with immovable property by reference to the lex situs. Now, that brings up the next slide, I think, please, Emma. And we'll turn to have a look at the effect of this statutory will as regards to property in Scotland. Now, remember, a statutory will may not be familiar to everybody, but a statutory will in England is made on behalf of a testator by an order of the Court of Protection, what orders a deputy to execute a will on behalf of the individual. And as is normally the case, what you get is just a standard, effectively a will in the usual form. So it will contain an express revocation of all prior testamentary writing. Now, to actually revoke an earlier will and govern the devolution of assets, a later will has to be essentially valid. Scots law decides the essential validity of provisions in a will relating to movable property in Scotland by applying the law of the place of the testator's domicile at the time of the death. And in the example here, that would be English law. And of course, under English law, the statutory will is validly made on Matt's behalf under the 2005 Act. So its effect is as if he had made it himself in relation to movable property. But again, and importantly, there's a different outcome for the immovable property here, because where a will deals with heritage in Scotland, again, essential validity is decided by reference to the lex situs. Now here we run up against quite an interesting twist, because the jurisdiction of the Court of Protection in England to make a statutory will is very, very different from the position in Scotland. In our hypothetical example, the Court of Protection has exercised its powers to order the making of a will on behalf of Matt, giving effect to what are understood to be his testamentary intentions, but after the point at which Matt no longer has capacity to express those intentions for himself. So the statutory will, which has resulted from the application to the court, is a modified version, as I mentioned, of the settlement from 2015, but it innovates by making generous provision for Francoise. There's no direct evidence of Matt's intentions in that regard at the time that will is made, but the court's jurisdiction in England under the 2005 Act allows it to make a will on behalf of an incapable person on grounds of best interest. That requires consideration of all the relevant circumstances, including, amongst other things, past and present wishes and feelings, the beliefs and values that would be likely to influence the person's decision if he had capacity, and any other factors that he would be likely to take into account if he could. For these purposes, best interest isn't actually substituted judgment as they use in the jargon, so it's not the court asking itself what would the testator have done if they had had capacity. Instead, it requires the court to make its own objective assessment of what would be in that person's best interest. It follows that even the expressed wishes of a testator, of an individual, can be disregarded, although they shouldn't be lightly overridden, and regard should obviously be paid to them. Next slide, please, Emma. Those powers, that suite of powers, is very, to Scottish eyes anyway, is extremely radical. It's a very different regime which operates south of the border in this area than the powers that are available in the Scottish courts in similar circumstances. Bear in mind that anybody claiming an interest in the property, affairs, or welfare of an incapable person can apply for an intervention order under Section 53 of the Act from 2000, and the sheriff has jurisdiction to make an order which requires the making of a will. But the applicant, as well as showing lack of capacity, must be able to evidence a statement of testamentary intention made at a time when the person had capacity. Now, rightly or wrongly, that's where things rest in Scotland based on the sheriff principle's clear conclusions in the case of Ward. And that's a very long way indeed from having power to act in the absence of evidence based on an objective assessment of best interest. The differences here beg the question of what will a Scottish court do when it's faced with a statutory will which deals with property in Scotland. Now, the answer is buried deep in the text of the Act of 2000 in Schedule 3. It tells us effectively that an order made by a court under foreign law for the protection of property of an incapable adult will be recognised in Scotland, providing the adult is habitually resident there. But for that order to have effect in Scotland, it has to have legal effect in the jurisdiction in which it's made. So one then has to look into the 2005 Act, which tells us two things. Firstly, a statutory will is deemed to have effect, but then there's an express carve-out. So, I mean, you have to be aware of this. You're looking at these things. There's an express carve-out which says under English law that if a statutory will makes provisions which purport to intromit, as it were, with property outside England and Wales, they don't have effect outside England and Wales. So effectively what you have is Scots law referring the question to English law answering back by saying this will is of no effect in Scotland. So where does that leave us in this hypothetical story? I'm conscious we must be running up against the hour mark very closely. The outcome from a tax perspective is that in relation to the Scottish estate in this scenario, the outcome is really suboptimal. The part of Matt's estate over which Francoise has her life interest is of course exempt from IHT on death as a result of the marriage, but there is scope in relation to that part of the estate for legitimate planning, because if Francoise, already well provided for, terminates her life interest under the statutory will, the assets will remain on discretionary trust. IHT would be suffered at 20% on the lifetime transfer at that stage. Tax is payable, of course, but that's a substantial saving measured against the inheritance tax liability that would have arisen under the 2015 will, providing, of course, that Francois survives for 7 years. Now, Roddy, I'm conscious that we must be at the or nearly at the 60-minute mark, so I think probably I've fitted as much as I can into the time available for us, and that really concludes everything I need to say, I hope, about my case study.
Gordon, thanks very much indeed. I can't see any questions having been submitted yet. There is still an opportunity, briefly, we are slightly over the hour mark, but as I said earlier, there is obviously an opportunity for people to email any of the speakers directly or together if there are any burning questions, particularly in relation to Gordon's talk. On the basis that nothing is coming through just now, thank you for your support. Thank you for watching today's webinar and the other webinars that you may have seen over the past few months during lockdown. We'll be delighted to assist going forward, and good afternoon.